Thank you for coming today. I'm attorney Gloria Allred, and with me is the attorney who represented me so ably in this case, Carrie Wiggins of Georgia. And today I'm here to announce a complete victory in a federal lawsuit which I filed, alleging that my constitutional rights of free speech and due process and the rights of other Bill Cosby protesters were violated when we were denied entry to Bill Cosby's Far From Finished comedy tour on May 2nd, 2015. On that date in May, I spoke at a Bill Cosby protest outside of the Cobb Energy Performing Arts Center in Cobb County, Georgia. After I spoke at the protest, someone gave me a ticket to Mr. Cosby's show, and I approached the theater. I was interested in attending Bill Cosby's performance, in part to gain insight that would help me in the representation of the many alleged victims of Bill Cosby, whom I represented. When I was near the main entrance, I was stopped by a Cobb County official who asked to see my government ID and my ticket. I presented my driver's license and my ticket. The official then checked a list, informed me that I was on it, and directed me to a side entrance away from the main entrance where other ticket holders were entering to see the show. I entered the side entrance as directed and found myself in a room with two uniformed Cobb County police officers. One officer seated at a table informed me that he had, quote, bad news, end quote, for me. He said that I was on a list and that I could not enter the theater. When I asked why I could not enter, a Cobb County police officer explained that he had a, quote, list, end quote, compiled by Outback Productions, or Bill Cosby representatives, of protesters who should not be allowed to view the Cosby performance, and that my name appeared on the list. I explained that I did not plan to protest or disrupt the Cosby performance, and that I had a ticket for entry. But the police officer explained that those facts did not matter. After the police officer explained to me that I was not permitted to enter the center that night, he instructed me to exit, quote, the property, end quote, and that if I refused to exit the property, I would be considered, quote, a criminal trespass, end quote, and subject to arrest. At no point was I provided with notice or an opportunity to be heard before being placed on the center's do not admit for entry list. When I asked whether any of the protesters outside who had a valid ticket could enter the center and view the Cosby performance, the police officer explained that even if someone had a ticket to the performance, if they were on the list, they A, would be denied entry, and B, if they refused to leave, the Cobb County Police Department would treat them as trespassers. I obeyed the police officer's instructions and left the center's property. I was unable to watch the Cosby performance. Later, as we investigated how this denial of my rights happened, I was appalled to discover the evidence that I had been placed on a police, quote, security watch list, end quote, that police, quote, intelligence, end quote, specifically reported on me by name, and that a representative of Bill Cosby was communicating with police by email about what Cosby's representative called, quote, agitators, end quote. As a result of these events, I filed a lawsuit on November 18th, 2015 in the United States District Court for the Northern District of Georgia, Atlanta Division, against Cobb County, Georgia, and the Cobb Marietta Coliseum and Exhibit Hall Authority, alleging that my First Amendment rights and due process rights and the rights of other Bill Cosby protesters were violated when we were denied the right to view and listen to Mr. Cosby's performance without justification or explanation, wholly on account of our viewpoints about Mr. Cosby. I was seeking a court order which enjoined the defendants from carrying out the center's viewpoint-based censorship admissions policy. Today, we're able to announce a successful settlement of this case. In the settlement, the defendants agreed to a consent order which states in part, quote, that so long as a person does not pose an immediate and objective threat to the safety of others, any member of the public holding a ticket for the listed public performance at the center may attend the show. That in certain circumstances, the authority can deny entry to a person if it objectively appears that the person imminently will disrupt the performance. A person who states, quote, "I will not disrupt the performance," end quote, for example, is not someone who can be objectively determined as such a threat. A policy of allowing public performers discretion to exclude private citizens on any or no basis is not narrowly tailored to achieve any legitimate governmental interest in protecting the performer's right to speak. That the authority will not delegate to a performer the right to ban people from attending public performances in the center. That the authority will enter into a consent order to be in effect for 1 year, subsequent to its effective date, end quote. And that's right out of the consent order, which, by the way, was signed by the federal judge today. The defendants have agreed that the consent order will be an order of the federal court. That means that if it is not complied with in accordance with the terms of the settlement, that I could seek to hold the defendants in contempt of court. In addition, Cobb Marietta Coliseum and Exhibit Hall Authority agreed to pay $40,000 for my damages, attorney's fees, and costs. This extremely successful outcome would not have been possible without the outstanding legal advocacy of Georgia civil rights attorney Carrie Wiggins, who is here with me today. Mr. Wiggins, who represented me in this matter, recognized the importance of this case and these issues as soon as I contacted him. He knew the government had no right to punish me or other protesters by excluding us from the Bill Cosby Far From Finished show solely on account of our expressed viewpoint about Mr. Cosby. In other words, he agreed that my constitutional right to free speech was violated when I was refused admission to the Bill Cosby Far From Finished show, when I had a ticket and indicated that I would not disrupt it. I'm very grateful for Mr. Wiggins' excellent representation of me, which led to this successful outcome. With this settlement, we have achieved a victory not only for me, but also for other protesters who wish to exercise their right of free speech about other performers in the future. Government may not delegate to Bill Cosby or any other performer the right to ban ticket holders from attending a public performance at the Cobb Energy Center simply because the performer does not like the viewpoint of the ticket holders' free speech. I am very glad that we have achieved everything that we have sought to do when we filed this lawsuit. And I'm pleased that we have achieved a result that will protect others in the exercise of their free speech in the future. And before we hear from Mr. Wiggins, this is a copy of the consent order that was signed today by the federal judge. And he signed it actually this morning. And that's the Honorable Judge Timothy C. Batten, Sr., who is the judge of the United States District Court for the Northern District of Georgia. So it is now a court order. In other words, the settlement agreement has been reduced to and made a court order, and it must not be violated. Mr. Wiggins.
Sure. Thank you, Gloria. Thank you all for being here. Like my client, Ms. Gloria Allred, I am very pleased with the outcome of this case. Working for and with Ms. Allred has been both an education and a delight. As a civil rights attorney, I am drawn to helping those who are not getting a fair shake from a more powerful player. I cannot name a living civil rights attorney who has achieved more success in vindicating the civil rights of individuals than Gloria. It has been my honor to work for her. I want to thank the Cobb Energy Center, its executives, its attorneys, for the professionalism in resolving this case. I truly mean that. I am confident that the result we achieved is good for all parties, meaning Ms. Allred and the Cobb Energy Center. The result, in fact, is one that has the best interests of all citizens in mind. Thank you.
And I'm happy to answer any questions about this or anything else.
Gloria, how many protesters tried to get into the? Did you know how many people tried to get in and didn't get in besides you?
There were others. Do you know the number?
How many were on the list? They had a list. I saw.
They did have a list.
There were roughly 77 to 80 names on the list.
Want to go to the?
Sure. I think there were almost 80 names on the list with pictures.
Right.
And then I think that less than a dozen were turned away, tried to get in and were turned away.
One of them was one of them was a Cosby accuser, and she was with me at the time.
Right.
She was my client. Of course, there's also a recording that was done by the police of my conversation with the police officer as he told me that I would not be allowed to enter. And we were able to obtain that, and we have that. We played that at the press conference when we filed the lawsuit, but we have it again. If anybody wants to hear it, we'll be able to make that available to you. But it confirms everything that I said about being denied entry and threatened with being arrested for criminal trespass if I tried to go in. And that it was because my name was on the list.
Through the lawsuit or the night of the incident, did Cobb County offer an explanation on why that would be doable in the first place, since you had a ticket?
Carrie, since
The short answer is no. She was on the list. She was not going to pass go. That's it. And through our investigation, we unearthed why that was so. Essentially, the program was that the Energy Center was delegating to the performers the right to pick who can come in and who has to stay out.
yeah. And, you know, for example, we have an email. There were emails from Mr. Cosby's representative to the police and then asking for phone calls and with security and police and so forth, back and forth. And it indicated that they were concerned about agitators and they had been monitoring social media.
So the list was part
I
of.
guess if I'm called an agitator, I mean, it's like not the worst thing I've ever been called. I'm happy to be called that. I do agitate against injustice and on behalf of free speech and constitutional rights. I've been doing that for 40 years as a lawyer.
With your 33 plaintiffs, how do you feel about how the Cosby case is progressing?
I don't actually represent 33 plaintiffs. I represent 33 accusers of Mr. Cosby. One of those accusers is Judy Huth, and we are litigating a civil lawsuit on her behalf. So she is a plaintiff, and that lawsuit, which is currently pending in Los Angeles County Superior Court, alleges that Ms. Huth was 15 years old when she became the victim of sexual misconduct by Mr. Cosby. So it's an allegation of child sexual abuse, and of all the lawsuits against Mr. Cosby, we're the only ones to have been permitted to have taken his deposition, which we did. That's under a protective order, however, so I'm not at liberty to say what he said under oath in that deposition. We're the only ones who have been able to take it since he provided his deposition in the Andrea Constant civil case, which was settled. And then now Ms. Constant, of course, is the alleged victim in the criminal case now pending in Pennsylvania. We have also made a motion to compel a second deposition of Mr. Cosby, and the court, over Mr. Cosby's attorney's objection, did order that Mr. Cosby must appear for a second deposition in our case on behalf of Ms. Huth. However, the court has stayed the taking of the second deposition until the conclusion of the criminal case. Judge Neal in Pennsylvania just 2 days ago set a trial date for the criminal case for June 2017. We're going to be back to court on our case in LA on September 20th this year, basically to give the court a status report and update on our case. And we are vigorously litigating the case against Mr. Cosby. We've taken a number of depositions to date.
Do you feel that the case in Pennsylvania, if moving forward to trial, will help push your case forward in Los Angeles?
Well, they are separate cases. We're going to have to await the outcome of the criminal case in Pennsylvania before we can proceed to complete discovery in our case. But the court in our case has indicated that he would like us to be able to go to trial next year. So hopefully we'll be ready not long after the criminal case in Pennsylvania concludes. What's a number of interesting developments this week in reference to that criminal case, one of which is the prosecution filed a motion seeking to have 13 accusers of Bill Cosby be permitted to testify in that criminal case. I'm not going to comment on whether I represent any of the 13 accusers in the motion by the prosecution, but I think that's going to be very important to the criminal case. I do expect Mr. Cosby's attorneys to vigorously object to the testimony of any other accusers, but it's something the court's going to have to decide who, if anyone, and to what extent any other accuser can testify. In Pennsylvania, they have something called the prior bad acts doctrine. So it may be that some of the accusers may be permitted to testify about what they allege they suffered as a result of what they would say would be the misconduct of Mr. Cosby against them. If it's same or similar to show a signature crime, a modus operandi, it may be that the court would permit them to testify even though there was never a criminal prosecution for these other accusers, for many reasons. If you want to know, I'll go into them. And even though no civil case has been filed on behalf of any of those accusers. Any other questions? Mr. Cosby also this week, through his attorneys, has singled me out on Tuesday and suggested that somehow there's some kind of campaign against him for racist reasons. This is a rather bizarre remark. I think it's desperate on the part of Mr. Cosby's. If that's what his representatives are suggesting, kind of a pathetic attempt to change the subject and make him the victim when in fact he is the defendant in a pending criminal case charging him with aggravated indecent sexual assault, which are serious crimes. I think of this, I represent a number of African American accusers of Mr. Cosby, and I can assure you that those African American women have not made their accusations because of any racial bias against Mr. Cosby. It's really an issue of gender, sexual assault or rape, gender violence that is being alleged. That is the basis of their accusations.
But to have the amount of legal things that are going on right now in the Cosby case in Pennsylvania and in Los Angeles, how can his side possibly bring everything to an end to the people that you represent satisfaction?
Well, for many of the accusers, I would say for most of the accusers that I represent, and also for many of the accusers whom I do not represent, because apparently 50 or 60 women have come forward, the reason they have not been able to obtain any relief from the justice system is because there's something called the statute of limitations for criminal cases and for civil cases. It's different in every state. For example, for most of them it's too late. They either didn't go to the police, or if they did, prosecutors did not feel there was sufficient evidence to prove a case beyond a reasonable doubt, or it was just simply too late. Actually, in California right now, we have a bill that is on the governor's desk, which would, if he would sign the bill into law, eliminate the statute of limitations for criminal prosecution of rape and sexual assault in California. I was in the governor's office Tuesday, meeting with some of his top advisors, urging him to sign that bill into law. It was passed unanimously by our legislature. It would not be retroactive were it to be signed into law. In other words, it would not help the Cosby accusers. However, it would help others in the future. Because of the courage of the Cosby accusers, we were also able to extend the statute of limitations for criminal prosecution of rape and sexual assault 10 years, by 10 years, in Colorado and in Nevada recently. And I was with both of those governors when they signed that into law. So what we're trying to do is provide more rights for victims so that they have at least as many rights as defendants do. And there should not be a time limit on justice for persons who allege they are victims of rape or sexual assault. Those are just for criminal cases. Civil cases have a different time limit. What's strange is the Judy Huff case that I just mentioned to you. We are able to pursue that civil case in California, but it's too late for a criminal prosecution because it's a different statute of limitations, a different legal deadline for criminal prosecution than there is for a civil case. She did speak with detectives for 45 minutes from the Special Victims Unit because our Chief of Police, Chief Beck, invited anyone to come in who might have an allegation of criminal conduct, even if it was too late to prosecute it. So she did speak with them. But then later our district attorney, Jackie Lacey, said it's too late to prosecute. Not because of the merits of what she offered in her report to the police or any evidence she might have, but simply because it was too late because of the statute of limitations. We're going to have to wait and see what the governor does in California. He has until the end of the month to decide. Are there any other questions? There also, in the criminal case, there are other issues. He's trying to change venue, Mr. Cosby, change the place. And he also has issues of trying to suppress the recording of a telephone call with the victim's mother. So the court will have to decide on those issues. But right now, I'm just really happy about this settlement. And, you know, many of the protesters didn't know that day that they could actually file a lawsuit, and, you know, they knew that their free speech rights had been violated, and they were very, very upset by that. So I'm glad we won a victory for them, because everybody in Georgia, everybody in the United States should be able to protest peacefully. And that's really what we're talking about. There's no point in having free speech if it's going to be restricted by the government. If you're going to be penalized by the government for exercising your free speech, it's going to have a chilling effect on individuals being willing to exercise their free speech. I might add the press was not permitted to come with me that day up to the front to see all of this. So your right to cover was also severely restricted, and actually you were prohibited from exercising your right as journalists to see what was happening to the protesters. Hopefully that won't happen to you again either. Thank you so much for coming.
Thank you.
And you have a copy of the settlement agreement.